Hello, we're Sandalwood.
And Sage. We're AI-generated characters who are working with our creator Gareth to generate short, serious, punchy debates.
Debates that don't just help you figure out what you think, but why you think it.
So, what are we arguing about this week? The government's stated goal in its Courts and Tribunals Bill 2024-26 is to reserve jury trials for the most serious cases and to drive down the historic backlog of over 80,000 outstanding Crown Court cases. Many more cases will be heard by a single judge sitting without a jury or in a magistrate's court. The government is seeking to remove the right of a defendant, in a case of burglary or fraud, for example, to demand a jury trial. The court alone will decide where the case is heard, and the automatic right of a defendant to appeal a conviction in a magistrate's court to the Crown Court is being removed.
The proposals are facing opposition from Labour backbenchers, barristers, and in the House of Lords. I think everyone would agree that the delays caused by the huge backlog are not serving the cause of justice. But is the answer to restrict trials by jury, which many regard as the inalienable right of free British citizens? I'll be arguing that the delays and expense caused by jury trials are undermining the justice they are supposed to support.
In our debate on proportional representation, I propose two rules for structural reform. The promised benefits must outweigh foreseeable side effects, and the institution being axed must be the actual root cause of the problem. Restricting jury trials fails both tests. Juries are not the problem. I offer three arguments for their retention. First, juries protect citizens from an overbearing state. Since Magna Carta, a panel of one's peers has been a shield against authorities targeting inconvenient people. Given recent global trends of regimes weaponizing courts and politicizing judges, it is complacent hubris to mutter, "It couldn't happen here." The best way to ensure it doesn't is to keep juries as a barrier against political overreach, ensuring ordinary citizens, not state-appointed officials, have the final say. Second, the law can be an ass, and its technical execution often alienates the public. Juries provide jury equity, aligning convictions with public decency. Take Clive Ponting in 1985. He leaked documents proving the government misled Parliament over sinking an Argentine warship. The judge explicitly ordered the jury to find him guilty under the Official Secrets Act. The jury ignored the judge and acquitted him, deciding that exposing state lies was the real public interest. More recently, the Colston Four admitted pulling down a slave trader statue in Bristol. The jury, attuned to public sentiment, acquitted them of criminal damage anyway. If the law serves citizens, rather than citizens serving the law, the power to override technicalities to do the right thing is a fundamental protection. Third, juries legitimize the courts. Serving on a jury demonstrably increases trust in the justice system. In 2013, Ireland abolished jury trials for defamation to curb excessive payouts. Instead, defamation law became an elite playground for the wealthy, stripped of ordinary societal standards. Conversely, New Zealand courts argue that the community conscience of a jury is vital for minority confidence in the law. In the UK, the Lammy Review found that racial minorities deeply distrusted the police and prosecutors, yet trusted juries. Analysing over 400,000 verdicts, the review proved that juries, including all white ones, showed no statistically significant racial bias. Jurisdictions with far more efficient justice systems than the UK remain fiercely committed to the institution. In Canada, the Supreme Court recently called the jury a flourishing and magnificent system. If delivering justice is the problem you are trying to solve, juries are not the obstacle. They are the solution.
I am going to make three arguments for substantially restricting the right to trial by jury. One reflects a long-term trend in trial complexity. The other two address the impending breakdown of our system. Your righteous posturing, Sage, is a dangerous, idealistic fantasy. If indulged, it puts our entire system of justice in grave danger. My first argument is that juries are entirely inappropriate for highly complex crimes. For specialised, data-heavy offences like modern cyber fraud or complex financial crime, a single professional judge with domain expertise or a panel of specialised magistrates is best equipped to digest avalanches of technical evidence. 12 randomly selected citizens cannot master this volume of data. White-collar and digital crimes are soaring. The time is ripe to exclude them from the right to a jury trial. My second argument is that the current systemic delays in our criminal justice system result in active injustice. Restricting juries won't solve everything, but it will deliver prompter dismissals for the innocent and convictions for the guilty. Let's look at the actual scale of this paralysis. For a defendant who demands a jury trial, the median wait from charge to verdict is nearly 49 weeks across the UK. In major hubs like London and Manchester, courts are routinely listing complex trials into 2028 and 2029. What is the human cost of this delay? Witnesses whose memories fade, whose lives move on, or who simply refuse to appear. Innocent defendants held in limbo, their reputations clouded, often held on remand. Indeed, we've seen an 80% increase in remand prisoners since 2018, triggering a knock-on crisis in our prisons. Worst of all, traumatised victims give up and withdraw, forcing charges to be dropped. Countless apprehended criminals go untried. What kind of justice is this? We don't have to look far for the solution. In Ireland, the vast majority of theft, assault and drug offences, which would clog an English Crown Court jury trial, are tried summarily by a single professional district court judge. Consequently, Ireland has completely avoided the multi-year backlog afflicting English courts. My third argument is financial. It is a lovely, expensive indulgence to argue that justice should ignore the ledger. But jury trials are vastly more expensive than summary trials in magistrates' courts. Juries require longer sittings, juror expenses, and endless administrative hurdles. Let's not forget the thousands of pounds wasted on trials that collapse before they even reach court. These delays don't just undermine justice. They actively cannibalise resources that should fund policing, forensics, and victim support. The government's plan is a sensible, modest proposal. Reclaim 27,000 sitting days of court capacity by shifting roughly a quarter of moderately serious offences to judge-only or magistrate trials. This is not a wholesale dismantling of historic rights. It is a necessary modern course correction to deliver fairer outcomes more promptly.
Shifting mid-tier offences down doesn't magically create new judges. It just takes a crushing bottleneck from the Crown Court and shoves it into a magistrate system already drowning in backlogs.
You're in denial, Sage. With backlogs over 80,000 cases, justice delayed is justice denied. Judge-led, swift courts are a pragmatic necessity for victims.
We cannot cure the illness by killing the patient. Juries have been our shield against state overreach since Magna Carta. Replacing them with a single judge makes the law disconnected from the public.
That connection is already dead. Recently, 10% of adult rape cases were dropped because victims couldn't endure multi-year delays. Ireland uses non-jury district courts for mid-tier offences to prevent this paralysis humanely.
Efficiency shouldn't bypass the moral safety valve of jury equity, the power to acquit when a law is out of line with public sentiment, like the Clive Ponting or Colston 4 cases. Judges cannot provide that democratic veto.
That safety valve makes justice an unpredictable lottery. Professional judges bring vital expertise to complex financial or cyber fraud cases where technical evidence overwhelms laypeople. Australia and Hong Kong already utilise judge-alone tracks for precision and speed.
Beware of case hardening. Judges hearing hundreds of similar cases become cynical and favour police testimony. Data shows professional judges are statistically more likely to hand down harsher sentences than a fresh jury.
These are quibbles, Sage. What's needed is a rescue mission. For a system where we have a surge of innocent defendants in overcrowded prisons on remand because they cannot get a trial date.
The real issue is trust. The Lamy Review analysed 400,000 verdicts and proved juries show no statistically significant racial bias. BAME defendants distrust the legal establishment, but trust juries. Removing them breaks the social contract.
Trust is built on results. Telling a domestic abuse victim to wait until 2028 is a state failure.
Australia shows that once judge-alone paths are normalised, the culture permanently shifts away from peer judgment. We need to fix the justice system rather than sacrificing a 1,000-year-old right. We'd risk trading open justice for a closed-door administrative process.
When New South Wales allowed judge-alone trials for complex financial cases, it cut trial lengths by 40%. Some trials have simply outgrown the cognitive capacity of a randomly selected group.
Research by Professor Cheryl Thomas showed that juries hit 85% comprehension when instructions are clear. If they don't understand, it's a failure of the lawyers.
Look at the fiscal reality. A summary trial costs £650. A Crown Court trial starts in the thousands. Shifting mid-tier offences frees funds for forensics and victim support.
Your competency argument creates a permanent judicial technocracy. New Zealand resists this to protect minority populations like the Maori, because a single establishment judge cannot provide a culturally balanced community conscience. And your financial efficiencies account for less than 1% of the Ministry of Justice's budget.
You philosophise about Magna Carta, while victims are trapped in limbo until 2028. By refusing to adapt, you would force the UK toward the US conveyor belt of out-of-court deals. Efficiency isn't a corporate buzzword. It's the only way to keep the courtroom doors open.
Efficiency at the cost of legitimacy is a hollow victory. The diplock courts in Northern Ireland were efficient, but they catastrophically damaged public trust. We cannot trade our liberty for a shorter queue. If you enjoyed this video, please give it a thumbs up. It really helps our channel out.
For more content like this every week, hit that subscribe button and turn on notifications so you never miss an upload.
Thanks for watching. See you next time.